Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Legally Speaking, the channel where we make sense of the law for you. I'm Melanie van Aarde, your host and a licensed paralegal. Today we are joined by Defense Counsel Dan Lemaire. Dan will be discussing an important topic. What is a conditional discharge? He'll explain how it works, when it might be used, and what it means for those involved. So stay tuned for this valuable conversation. So Dan, what exactly is a conditional discharge and how does it differ from other types of discharges or sentences?
Sure. So a conditional discharge is a finding of guilt, but the court does not register a conviction against the offender. So in other words, although the court has actually found you guilty of the offense, the court doesn't enter a conviction onto your criminal record. That differs from other sorts of sentences where not only have you been found guilty, but you also have that conviction registered against you.
And then what are the typical conditions that might be attached to a conditional discharge?
So a conditional discharge will typically involve a period of probation, usually in the range of 12 to 36 months. That will usually require the offender to keep the peace, to report to a probation officer, attend counseling, not possess any weapons. Depending on the circumstances, the court may also order that there be restricted contact or communication between any victims or witnesses in the case.
And then lastly, Dan, how does a conditional discharge impact an individual's criminal record, both immediately and in the long term?
So although a conditional discharge is not a conviction, it still will show up on certain types of record checks. So there are 3 types of police record check. There is a police criminal record check, a police information check, and a vulnerable sector check. Those last 2 that I mentioned will show that conditional discharge for a period of 3 years. After 3 years, the conditional discharge should not appear on any level of criminal record check. But because of that initial 3-year period, it could still impact your employment, your ability to volunteer, your interests in family court, and things like that, even though it's not a conviction.
Thank you so much, Dan, for discussing a conditional discharge with us. And thank you everyone else for joining us on the Aitken Robertson YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defense. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.